breaking news just coming into our newsroom right now. The Supreme Court has issued a ruling on ghost guns.
The American people deserve and they have the right to defend themselves, and that's what we're fighting for.
Virginia has almost every conceivable form of bad gun laws that could be proposed or copied from places.
You probably expect that I'm going to tell you that, nah, it's really not that bad. No, if I did that, I'd be lying to you. It totally sucks.
It will drastically change how the landscape will look for Second Amendment rights in Virginia.
The General Assembly is addressing some hot-button issues in this year's legislative session.
A bill just landed on the governor's desk in Virginia that could send you to prison for 10 years, not for committing a violent crime, not for threatening anyone, but for building something in your own garage that Americans have legally built since before this country even existed. And here's the part that should make every single gun owner in America pay very close attention. There is no grandfather clause. If you already own one, you're a criminal overnight. But this bill isn't even the scariest part of what Virginia is doing right now. There's a second piece of legislation moving through that state that, when you connect it to this one, reveals something far more alarming about where all of this is actually headed. Let's get into exactly what just happened. House Bill 40 has officially cleared both chambers of the Virginia legislature. It passed the House, moved through the Senate, went back to the House for final reconciliation, and now it sits on Governor Spanberger's desk. She will sign it. There is no question about that. And when she does, Virginia will have enacted what might be the most blatantly unconstitutional firearms law in modern American history. That's not hyperbole. That's not exaggeration for effect. When you actually read what this bill does and then hold it up against established constitutional precedent, the conflict isn't subtle. It isn't a gray area. It's a direct, open-handed slap to the face of the Supreme Court. So what does HB 40 actually do? At its core, this bill bans the manufacture and possession of any firearm that does not carry a serial number issued by a federally licensed firearms dealer. That means DIY firearms, self-manufactured firearms, 3D printed firearms, anything you built yourself or acquired without going through the traditional FFL process. All of it becomes illegal in the Commonwealth of Virginia the moment this law takes effect. And the penalties they attach to this aren't slaps on the wrist, they aren't fines, they aren't misdemeanors. Manufacturing one of these firearms carries a punishment of up to 10 years in a state penitentiary. 10 years. For assembling a firearm in your own home, something that has been perfectly legal for the entire history of this nation, you could spend a decade behind bars.
Virginia Democrats are moving forward with several bills they say are meant to reduce gun violence in the Commonwealth.
That if you're going to sell a gun like this, you've got to do a background check, you've got to put a serial number on it.
If you're in another state and you're like, well, it sucks to be in Virginia, that's never going to happen here. Yeah, people in Virginia were saying the same thing a few years ago.
This approach will gradually take the weapons off the street without making it a crime to own a weapon that was legally purchased.
They have no place in our communities. Neither do the extended magazines that contribute to so much misery.
Back in 1776, Virginia's Article 1, Section 13 protected your right to arms.
Now, possession carries its own penalties, and they're structured to escalate. A first offense for simple possession is punishable by up to 1 year. A second offense jumps dramatically, 2 to 10 years. But here's where it gets truly outrageous. The act of manufacturing, which in practical terms means the act of putting the components together, assembling the firearm, that's the 10-year felony right out of the gate. No prior offenses needed, no criminal history required, just the act of building it. And remember what I said about there being no grandfather clause. That detail cannot be overstated. If you built a firearm 5 years ago, completely legally, following every law that existed at the time, and you still have it in your safe today, this law retroactively turns you into a criminal. You didn't do anything new. You didn't break any law when you acted. But Virginia has decided that your past legal behavior is now punishable by imprisonment. Think about the precedent that sets. Think about what that means for every other right you currently exercise legally today. Now, let's talk about why this is so clearly unconstitutional, because this isn't one of those close call cases where legal scholars can argue both sides. The Supreme Court's Bruin decision established a very clear framework. To determine whether a firearms regulation is constitutional, you have to look at the text, history, and tradition of the Second Amendment. That's the test. And when you apply that test to self-manufactured firearms, the answer is so obvious it almost doesn't require analysis. There were no federally licensed firearms dealers at the time of the founding. The concept didn't exist. Every single firearm used in the Revolutionary War was either self-manufactured, produced by a local gunsmith, or imported. None of it went through anything resembling the modern FFL system. The musket a Minuteman carried at Lexington and Concord didn't have a government-issued serial number on it. The rifles used throughout the Civil War, the firearms that settled the American frontier, the weapons that defended homes and families for over 2 centuries of American history, the overwhelming majority of them were produced without any government serialization whatsoever. DIY firearms aren't some modern loophole. They aren't an aberration. They are the tradition. They are the history. Self-manufacture of firearms is as deeply rooted in the American experience as the Second Amendment itself. So, if this is so clearly unconstitutional, why is Virginia doing it? Why are they willing to pass a law that will almost certainly face immediate legal challenge?
And what you're about to go through is incredibly painful and will be immensely infuriating as well.
They're going to treat it like a gun, and you've got to get those serial numbers on it to sell it and background checks as well.
Today, a Senate committee approving bills affecting assault weapons, safe storage, and more.
A Virginia Senate committee advanced several bills that would tighten gun laws. One bill would create a Class 1 misdemeanor.
Virginia's Senate Courts of Justice Committee approving several bills on Monday, including ones to regulate ghost guns and more.
This is where things start to get really interesting, and honestly, really unsettling. You have to ask yourself a simple question. What makes an unserialized firearm different from a serialized one in the eyes of the government? The answer isn't about safety. There is zero statistical evidence, none, suggesting that self-manufactured firearms are used in violent crime at any rate that would justify this kind of draconian response. The people who have the knowledge, tools, and interest to build their own firearms are overwhelmingly law-abiding citizens. This isn't about public safety. It never was. The difference is knowledge. The difference is control. When you purchase a firearm through an FFL, a record is created. A background check is run through the system. The FFL maintains that record, and when that dealer eventually closes up shop, those records get sent directly to the ATF. Now, officially, the government isn't supposed to maintain a centralized registry of firearms owners, but it's been revealed repeatedly, and this has been documented extensively, that the ATF has maintained something like 1.1 billion records from background checks in their system. So while it may not be called a registry, functionally, if you bought a gun through a dealer, the government has a pretty good idea that you have it and roughly where you are. Self-manufactured firearms exist completely outside that system. The government doesn't know they exist. They don't know who built them. They don't know who has them. They don't know where they are. And for a government that wants to maintain maximum control over civilian firearms ownership, that is an intolerable gap. HB 40 isn't about preventing crime, it's about closing the one remaining blind spot in the government's ability to track and account for every single firearm in civilian hands. And this is where the second piece of legislation enters the picture, and this is where the full strategy becomes visible. House Bill 702 is moving through Virginia's legislature, and what it does is mandate that every single locality in the state, every city, every county, must establish a firearms buyback program by January 1st, 2028. Now, participation in these buyback programs isn't mandatory for citizens yet. The law requires the programs to exist, not that you turn in your firearms. But stop and think about what's being built here. Connect the pieces.
Democrats are moving forward with several bills they say are meant to reduce gun violence in the Commonwealth.
So if you don't pay careful attention to what's happening, this could be on your doorstep at no time.
And if you are convicted of it, then you would be barred from owning firearms for at least 3 years post-conviction.
The court is allowing the ATF to go ahead and regulate these kind of ghost guns.
First, they're ensuring that every firearm in civilian hands is serialized and known to the government by criminalizing any firearm that isn't. Second, they're requiring every locality to have the infrastructure in place to collect firearms from citizens. The architecture of confiscation is being assembled right in front of everyone, piece by piece, law by law. You don't build mandatory buyback infrastructure in every city in the state unless you intend to use it. And you don't criminalize unserialized firearms unless you want to make sure that when the time comes, there's nothing out there you can't account for. If you're sitting in Texas or Montana or Florida right now thinking this doesn't affect you, you're making a dangerous miscalculation. Virginia is the test case. Virginia is the blueprint. What works there gets exported everywhere. Every single gun control strategy that has gone national started as a state-level experiment. This is the playbook, and it's being executed with stunning speed and efficiency. The pace at which Virginia's legislature is moving on these bills is genuinely unprecedented. They are not slow-walking this. They are sprinting. Now here's the uncomfortable political reality. The Virginia Senate is split 21 Democrats to 19 Republicans. Everything that just happened, every single one of these bills could have been stopped by a shift of just 2 seats. 2, that's the margin. And that should tell you something about how much state and local elections actually matter. It's easy to get consumed by national politics, by presidential races and congressional battles. But the laws that most directly affect your daily life, the laws that determine whether you're a law-abiding citizen or a felon, those get written in state legislatures. And right now, in Virginia, the people writing those laws are openly hostile to the Second Amendment in a way that goes beyond anything we've seen at the federal level. The one saving grace in all of this is the current Supreme Court. The Bruin decision established a framework that should make HB 40 extremely vulnerable to legal challenge. The court has shown a willingness to take the Second Amendment seriously in a way that hasn't been seen in generations. But court challenges take time. They take years. And in the meantime, people in Virginia are going to be living under a law that can put them in prison for a decade for exercising a right that Americans have exercised since the founding of this nation. What's happening in Virginia right now is not a drill. It's not theoretical. It's not a slippery slope argument. The slope has been greased and people are already sliding. Every gun owner in this country needs to be watching what happens next, because if this succeeds in Virginia, if these laws stand, if they survive legal challenge, if they become the accepted norm, they're coming to your state next. That's not fear-mongering. That's pattern recognition. That's it for today, folks. See you in the next video.